Good afternoon, everyone. Thank you for joining this two-day webinar on efficient public procurement complaints mechanism and the role of an independent review body, which is organized by the Institut des Finances Basil Fuleihan in partnership with the World Bank and OECD-SIGMA. We are pleased to welcome the Chair of Parliamentary Committee discussing the draft procurement law, MP Mr. Yassin Jaber, and committee members, MP Mr. George Aes, MP Mr. Nicolas Nahas, MP Mr. Alaoun, and of course, who just joined, MP Mrs. Rula Tabush. We also welcome the President of the Institut des Finances Basil Fuleihan, Mrs. Lamia Mbayid Bsat. We are organizing this webinar at a time when the new public procurement draft law is being discussed at the Lebanese Parliament in a special parliamentary committee. And as you know, discussions of the draft law are towards the end. A first reading was completed and we are about to finish the second reading. However, one of the last issues that still need to be agreed on is a complaints mechanism that would ensure the effectiveness and efficiency in handling procurement complaints in the pre-contractual phase, and in the same context, the establishment of what we call a new procurement review body, which will handle reviews and complaints before contract signature, with focus on its status, mandate, and governance, and to ensure its independence and efficient functioning. We are conscious that the legal tradition in Lebanon puts the State Council at the center of complaints handling. However, the MAP's assessment findings have shown that there is a gap at this level and that a well-functioning procurement system needs a new approach to this subject. Therefore, we are in search of the optimal solution that fits, on one hand, the context of our country, and on the other hand, preserves the alignment with international standards and good practices. So this is the current situation. The issue is critical and the challenges are of many folds. This is why we are trying to bring other countries' experiences to level the field of knowledge and shed lights on particular things that are still not very clear to us, and see in other countries what worked well, what worked less, with the aim to avoid some shortcomings and minimize challenges and risks. This is the current situation. The issue is critical and the challenges are of many folds. This is why we're trying to bring other experiences to level the field of knowledge and shed some lights on particular things that are still not very clear, and see what worked well in other countries, what worked less, of course, with the aim to avoid same shortcomings and minimize challenges and risks. Today and tomorrow, the webinar is an opportunity to interact with international experts and address concerns and questions that we still have, so that we can establish an informed discussion. So on this first day, we will explore the international requirements in a efficient complaints mechanism, and we will go through the governance, the institutional challenge related to this procurement review body, while highlighting the recommendations of MAP's assessment for Lebanon, specifically for this issue. We are pleased to have a keynote address by MP Mr. Yassin Jaber on this occasion. Then we will tackle country experiences, starting with Denmark, and then open up the discussion. Tomorrow, we will have representatives and experts from Georgia, Croatia, and Romania to share their respective experiences in establishing review bodies. I would like to thank our partners, the World Bank and OECD-SIGMA, for their support, and our speakers who made themselves available to share our audience essence of the international experience in this domain. Before we start, allow me to add a logistical note. We invite all the participants to interact by writing their questions in the chat box anytime during the webinar. Of course, we will be allocating time for discussion and Q&As after the presentations. Also note that this session will be recorded and posted later on the website of the Institute and the social media. You know that we may face some technical problems related to the internet connection or electricity cut. So in case the platform cuts, kindly reconnect using the same link. Now I give the floor to Mr. Daniel Iverson, international expert in public procurement, who led the MAPS assessment in Lebanon and who is currently our strategy advisor. Mr. Iverson, the floor is yours.
Thank you very much, Rana. Indeed, I would like to start with giving a general overview of established international practice for procurement review and remedies. At the same time, it is something where practice in individual countries may be a little bit different. There is a certain flexibility, so to speak, in the approaches, and it is important to find a solution that applies to the needs and the situation of the particular country. But apart from that, there are a number of principles and practices that we would find in practically all countries where there is a system for review of complaints in the pre-contractual phase of public procurement. And this serves as a means for access to justice, in the first place for aggrieved tenderers or prospective tenderers, possibly their representatives. They may not necessarily have to complain themselves if there is an organization representing them that could take on this duty. The subject covers, in principle, the different decisions, the actions, or the failure to act by procuring entities when they are carrying out public procurement, when they are applying the public procurement law, or other legal instruments that regulate public procurement. And indeed, anything, planning, preparation, tender documents, and so on, that are prepared, and actions, decisions that are taken before a contract has been signed. The focus of such a system is on individual cases in the first place, in response indeed to complaints that are lodged by tenderers, prospective tenderers, because they have seen something which they suffer from or potentially would suffer from if it is not corrected. And general issues of policy and practice in public procurement would normally be dealt with by other means. The same applies, of course, to contractual disputes once a contract has been signed and is being carried out. And also matters like fraud and collusion, corruption, especially on the side of the tenderers, are also normally dealt with by other means. The importance of this is that a well-functioning review system helps ensure that violations, including mistakes which are completely unintentional, can be corrected before a contract is signed, when everything is much more difficult to sort out. This has the advantage, of course, that it builds trust in the system for all stakeholders, the procuring entities, businesses, taxpayers, citizens in general. It helps achieve value for money through transparent procedures, procedures that guarantee equal treatment, non-discrimination, and in that way support and encourage participation, better competition, and less corrupt and fraudulent behavior. And the decisions of the review bodies, first instance, second instance, also have the effect of helping clarify and unify the application of the law. And an additional final benefit is that it highlights also what is working and what is not working in the public procurement system. So this creates an evidence base for policy making and also for information and training. Now, why is this needed? What are the reasons for complaints? What is usually going wrong? Well, in the preparation phase, before evaluation is carried out, there are a few topics which very often come up. Deadlines for submission, for example, may be too short in order for well-qualified tenderers to prepare good proposals. Someone may have received advance information and then could be in an unduly favored position for bad reasons. And consequently, the deadlines for submission may need to be adjusted. It is also quite common that there are shortcomings in the requirements, in the specifications, in the conditions and the evidence required for demonstrating qualifications that are needed by the tenderers. And the award criteria may also not be adequate. They may all be either too biased in favor of a particular company, or too restrictive so that they limit competition, or simply too unclear and incomplete and vague, so it is very difficult to properly, clearly determine who is the best tenderer, who is fully qualified, who is not, and which tender is the best one. And indeed, when these different criteria requirements are applied in the evaluation and award phase, there may be other problems. It could be that actually a procuring entity carries out procurement without having published any notice or launched any kind of competition under circumstances that are not allowed by the law. Then there should be a possibility to complain against that. There may also be a failure to properly apply the grounds for exclusion or the requirements for qualifications or the technical requirements and award criteria. So against this background, there are a number of general objectives that we can formulate for a well-functioning procurement review system. It has to be a clear delimitation of the scope of it, what can be complained against, when, at what stage in the process, by whom, and of course, by what means, by what procedures. It should be available to all tenderers and prospective tenderers as a minimum without any discrimination. It should achieve legal certainty and consistency of the decisions, so that there is indeed a coherent and consistent, well-established case law established by the decisions of the review body. It has to be timely so as not to delay procurement. The decisions have to be taken in full consideration of all the technical and legal and other aspects of the individual case. So it's not just a matter of formal compliance with the law, but also a practical issue of how it can be applied in the particular case. And it is also important to ensure transparency on the procedures, on the complaints made, and the decisions taken, so that people can study and learn from what has been decided, so that contracting authorities, procuring entities, know how to prevent any complaints from arising, and that tenderers know what is possible, what is not possible or not appropriate. And in that way, we get effective prevention or correction of unlawful actions or decisions by procuring entities. We help achieve the public procurement objectives, and we use administrative resources in a more efficient manner. So again, this would in turn lead to better trust in the public procurement system, better relations between public and private sector, greater participation and thereby greater competition and better outcomes of public procurement, less or no need for prior review or advance authorizations, which are time-consuming and create confusion and dilute the responsibility of the procuring entities. It also has the effect in the medium and long term, in particular, to reduce or prevent violations and mistakes, and leads to a better interpretation and understanding of the law, and thereby less room for fraud and corruption, and more efficient and effective public procurement. So if there is something that a tenderer is not happy with at some stage of the procedure, the normal sequence of the steps to take starts, in fact, before contract signature, as soon as a notice is published and tender documents have been issued. If there is something tenderers are not happy with in that respect, in that stage, then they had better ask directly the procuring entity to clarify or rectify the problem, and they may give reasons for it. This is not very different from the usual practice of simply asking for a clarification to tender documents, but doing so in a systematic manner would already allow a number of problems to be sorted out at an early stage, even before any need for legal process or something. And indeed, experience shows that if there are good reasons for the request for clarification or correction, then the procuring entities will do something about it, extend the deadline for submission, correct, reissue the tender documents, and then there is no need for a formal complaint. If the procuring entities do not take such decisions, then of course there would have to be a formal complaint to the first instance review body, which will rule on the case and apply the different remedies that are foreseen in the law. And if again that decision is not to the liking of the complainant, then there should normally be a possibility for a second instance body to carry out judicial review of the decision of the first instance body. So this sums up a little bit the international standards and requirements. And indeed, if we look at the example of the government procurement agreement under the WTO, it says that challenges, that is complaints against procuring entity decisions, shall be heard by a court or by an impartial and independent review body with no interest in the outcome of the procurement, and the members of which are secure from external influence during the term of appointment. And consequently, we have different models in practice for the institutional framework and the enforcement of review body decisions, whether they are specialized procurement review bodies or courts, and of course also looking at the enforcement of their decisions. It is very important, I would say, to recall in this context the importance of some of the general objectives of the public procurement system and of the review system, and especially the need for rapid resolution of any complaints, the need for the decision-making review body to have a good knowledge and understanding of all aspects of the issues at hand, procurement practice and regulations, other legal issues, but also the technical aspects of the goods or works and services and the way they can be procured and used. And then, of course, the choice will, to some extent, depend on the characteristics of the bodies that may already exist or that possibly could be created or could be given this responsibility. There are a number of general requirements for a review body, which is not a court. I will not, in the interest of time, go into details here, but among the general requirements, we have, first of all, the status and independence, particularly the independence of the procurement review body as an institution, that is independence from the parties to the public procurement procedure, functional independence from the government, which is by itself, its ministries, a very important party in public procurement transactions. And the review body must also have adequate financial and administrative resources to carry out its work. And similar considerations apply also to the independence of the members, the decision makers of the review body. They have to be appointed by a body that normally should also be independent from the parties to the public procurement procedures. And this is why in many countries, the members of the body are appointed by Parliament. They would also have to abide by strong and clear requirements for competence and for eligibility, and they should be adequately protected from interference and pressure. They should have no conflicting engagements or interests, and they should also be possible to dismiss only in very exceptional cases and in principle by the body that appointed them. So such a review body would then normally have the competence to examine complaints, to request information from the parties, to engage external expertise, so-called witnesses. But normally the review body would simply rely on the submissions by the parties. Usually that is quite sufficient for the purpose. And there are then three main types of decisions that would be taken. Either the complaint is dismissed as unlawful or late or otherwise irreceivable, or it is rejected as unfounded, or it is accepted, and then the review body will take a decision on the remedies that should be carried out. So what are these remedies? We have some differences between the countries, a little bit depending on the legal system, but typically at an initial stage, there would be what is referred to as interim measures. That is a suspension of the implementation of any decision by the procuring entity, or the suspension of the whole procedure, and sometimes some kind of provisional correction of a breach of the requirements or regulations. And this is in order to prevent situations that no longer can be changed, and in particular to avoid the unlawful exclusion of a tenderer or a tender from evaluation, and to prevent a contract from being signed before a complaint has been heard. And depending on the stage of the procurement procedure, there would also be a number of measures to set aside decisions by the procuring entity, to remove discriminatory or other unlawful details in notices or tender documents or other documents in the procedure. It could be the annulment of an unlawful award decision or a decision to sign a contract. And it may be a positive correction of any unlawful document or contracting decision. And this would then have the effect of cancelling or making ineffective or changing an unlawful decision by the procuring entity, and to, in that way, correct any proven irregularities. Now, how this is done in detail is something that we will hear about a few examples of. And there are also some particular issues related to the situation in Lebanon that we will try to keep in mind when doing so. But with that, I hope I have not gone too much over the time allocated for this introduction, and I look forward to continuing working with you during this webinar on the other points to be raised.
Thank you very much, Daniel. Thank you. Before we continue, please allow me to welcome participants. Before participants, also we have another member, MP member of the committee, parliamentary committee, Mrs. Rula Tabish. Also, I would like to welcome her, and welcome participants from the State Council, Central Tender Board, the Court of Accounts, Ministry of Finance, the Presidency of the Council of Ministers, the Ministry of Interior, the Ministry of Education, Internal Security Forces, the CR, Council for Development and I also the private sector joined, and civil society organizations also are joined this webinar, and of course our national participation on webinar, the World Bank and OECD. Also, we welcome Expertise France, the French Embassy, United Nations, and other partners. So now we give the to Excellency Mr. Yassine Jaber, Chair of the Parliamentary Committee, to give his view and the view of the committee and to comment on the topic. Your Excellency, the floor is yours.
Thank you, Rana. Actually, I'm not going to take long. I'm going to leave more time for the experts. First, I'd like to thank Mr. Aberson, Daniel, for his introduction, which is very informative. And I think he gave us some very good ideas to really think about when we are working on the law. I'd like to thank you and the Fuleihan Institute and the World Bank and OECD for organizing this webinar. Although we're passing through difficult times, but I'm happy and grateful that you could do it in spite of all the obstacles that we are facing these days. I'd like to welcome my colleagues who have joined us on this webinar, and also welcome all those who are participating. And of course, their participation is very important for us because, as you know, we should all consult on these issues. As everybody knows, we are quite advanced in looking at the law. It's a challenge because it's one of the most important laws that we have to really pass. We are looking at a law, past law that's been there for 57 years, and we are now doing something which is very modern, trying to better experience what as my colleagues know, and you know, Rana, we are, and all those who participate with us, we are advanced, as I said. One of the most challenging issues from the beginning has been create this independent review body. You know, the complaints mechanism has been one of the issues that has been debated. And we hope that the various country experiences and the experts' opinions that you are today brought into this webinar, we could benefit to really come up with something that works both for us and for all interested. Of course, I would like to say that when we create this complaints mechanism, we are not actually taking away that the issue of the State Council. I mean, they are at the end of the day the body for the last resort. I mean, that's where things will end up if the complaints mechanism doesn't work. But as you know, Daniel said very clearly, what are the many benefits of having an independent complaints mechanism for public procurement. So I will listen to all the opinions, and I hope we'll have some written ones to bring along to the committee to look at and try to take advantage of. And I will, again, thank everybody and hope we have a good webinar today and tomorrow. Thank you.
Thank you, Your Excellency. Thank you again. And now we give the floor to Mr. David Bernstein, Lead Public Sector Specialist from the World Bank. Mr. David?
Hello, good afternoon, everybody. My name is David Bernstein. I've been at the bank for a number of years as a lead public sector specialist. My focus has been on justice reform and anti-corruption. So I'm not a procurement specialist or a procurement expert, but I do work very closely with procurement colleagues at the bank. And I think I was asked to kind of come at this issue from the angle of the impact on the judiciary and the kind of the justice system impact of complaints during a procurement process. I have worked for probably about 25 years or so on justice reform issues, primarily in Central Europe, but also globally. And from my experience, one of the problems we often see in countries, in justice systems, is an overloaded court system. Whether it's the civil courts or it's the administrative courts like the Council of State. We often hear complaints from the judges and even from the citizens that it takes too long to get justice, to get disputes resolved. Or that they can't even get in the courthouse door because of delays and backlogs in the cases. Our work has shown that these backlogs usually fall into two categories. One is kind of small claims, what we would refer to in the West as kind of a small claims court issue, unpaid bills, small disputes between individuals or between businesses. And another large group of cases are cases against administrative decisions. So when an agency makes a decision on a license, on granting a payment or disallowing a payment, citizens have a right to dispute that, but oftentimes these disputes overwhelm an administrative court system. This is something that we see and I've seen in many countries, which leads me back to the discussion that and the points that Daniel made about a role of an independent review body. This review body that we've worked with and seen in a number of countries can cover a range of administrative decisions and a range of administrative actions. But it almost always includes public procurement. As most of you know, public procurement is a huge part of just about every country's budget. Decisions made during the public procurement process are generally decentralized. The procurement is usually done at an agency level, and that leads to a number of points for dispute and points for issues to be raised bidders, by tenderers, and that leads to these types of disputes that tend to block up the courts. When faced with these types of issues, what many countries have done, there's usually kind of two solutions. If the issue is on the small claims, then oftentimes there's procedural changes to speed up the process or to create a separate process to address those types of disputes. If the problem is the administrative claims, disputes with administrative agencies, such as disputes with during a procurement process, then oftentimes what we've seen is the way to resolve those disputes is to push the dispute back into the agency level. So to move the dispute out of the formal court system and back into the administrative system. At least at the initial levels, in the initial time of the dispute, in order to have it more resolved more quickly and before it gets to court. What this means in practical steps, I think Daniel laid out pretty well, in that in many cases, the independent body provides kind of a protection against conflicts of interest, and allows for, I think, a more disinterested evaluation. It also has the appearance of just being separate, right? In jurisdictions and countries where corruption and influence are quite dominant, it's quite important that the decisions both be made independently and appear to be made independently. And that is a value of the model that sets up an independent institution outside of the administrative agency. Let me finish by just, I think, emphasizing a couple of points that that Daniel made about why these bodies, these independent bodies, kind of placed between the agency and the court system, why they have some advantages. The first one, I think, is the advantage that I've been focused on, which is efficiency. When you're dealing with public procurement decisions, the ultimate goal is not just to spend money, but it's to spend money for the benefit of the citizens. It is to purchase a service, it is to purchase goods so that the agency can do its job for the benefit of the Lebanese citizens. The faster that process moves, the more quickly benefits get to the citizens. And so when setting up a review process as part of the public procurement reform in Lebanon, I think that should be kept in mind. What would be the most efficient way to move these disputes along? And since we're talking about disputes at the pre-contractual level, then the other advantage that the independent body brings is expertise, or at least the ability to have experts in that body. Oftentimes these disputes involve could we call it kind of the arcane procurement procedures and arcane procurement language, which is not necessarily something that a judge who would be perhaps looking at disputes on education issues or disputes on on some energy regulation would necessarily be familiar with. So the independent body has the advantage of being able to be staffed with experts and with people who are well versed in the procurement procedures and the procurement rules. And I think that also allows these disputes to be resolved more quickly because you're not spending a lot of time educating yourself on the rules. You're actually interpreting and applying something that you know very well. And that is actually part of your, ingrained in your daily work. That is what you focus on. That is what the people in these independent agencies focus on, and that is what they do. And I think that is an advantage that the model of an independent body has versus the model that we have in the United States, where we have judges kind of sitting in an agency. Let me just close by bringing this back to my understanding of the Lebanese context. It's my understanding that, at least right now, there are no first instance administrative courts in Lebanon. So if an independent body is not set up to handle procurement disputes, then these disputes would go to the Council of State. And I think that lends itself to a number of the problems that I pointed out at the beginning about backlogs and expertise in adjudicating and resolving these disputes. The other issue, I guess, is that right now, I know there is a parallel effort at judicial reform, at reforming the judicial system in Lebanon. But that is moving at a much slower pace than your review and your process in adopting the public procurement law. So I think, in one sense, the Parliament faces a bit of a dilemma. You could try to put the dispute resolution process into an unreformed Lebanese court system. Or you have a choice between doing that or setting up an independent body. The other option is to wait for the judicial reform process to play out and to see how that impacts the Council of State and how that impacts the ability to handle administrative disputes in Lebanon. I think given, as the chairman noted, given the progress that the committee's made in the public procurement law forward, I would think that that it would be Lebanon would be well served by passing the public procurement law as soon as possible, and putting in place a system that allows for both an efficient and an expert resolution of these early procurement disputes, so that you get the benefit of the public procurement, and that's so that you don't feed back into the problems that are facing the Lebanese judicial system. So I'm going to stop there and be happy to take questions and participate in the discussion today. Thank you very much.
Thank you very much, David. Thank you. Before going back to Daniel, I would like also to welcome another member of the parliamentary committee. I see that Mr. Alaoun, member also of Parliament, has joined. You're welcome. Now I give the floor to Daniel again to highlight some issues of the findings of MAPS, which are related specifically to this topic, the mechanism review. Please, Daniel.
Thank you, Rana, and thank you also to David, who already gave some indications of problems that indeed will need to be resolved. I will now refer to the findings and recommendations of the MAPS assessment that was carried out mainly last year, and which has covered a number of issues: regulatory and institutional framework, the practices of public procurement, and related matters of transparency and integrity, and in that context also the question of how procurement complaints are reviewed and addressed. So if we start with looking at the regulatory framework and the shortcomings, the specific shortcomings that we have identified there, it is first of all an absence of clear and specific regulations that are focused on the on how to resolve complaints in public procurement, and in particular to do that in a way which makes sure that the decisions are taken as quickly as appropriate, and that the quality of the decisions is adequate. And indeed, public procurement issues are not just a legal matter where you would be able to expect any judge to read the law and then apply it. It is very much a matter of practical measures to create, in a way, an artificial market where the supply side, in a way, has a monopoly and therefore has to organize itself and carry out work in a way that nevertheless creates a competitive environment, and where the supply side, the enterprises, can participate, compete on things like quality and conditions in order to meet the requirements in the best possible way. And this is one of the reasons why it is also important to consider the need for knowledge of the procurement aspects and the technical sides of whatever goods and works and services are procured. And for the moment, there is not only no regulation that specifically addresses these problems, there is also no body specifically designated to deal with complaints. There is a general requirement, if you like, to assign pre-contractual disputes to the State Council, but there are some problems in that respect which I will get back to. And consequently, there are no mechanisms available for the moment to meet these basic requirements of speed and quality of reviews and decisions. So correspondingly, the recommendation is to review and revise the approach to handling complaints and to establish, due to the shortcomings of the current system, an independent review body in line with international good practice, with the required authority and skills and resources. So this is, in broad terms, one of the outcomes, the findings and recommendations of the assessment in terms of the regulatory and partly the institutional framework. If we now look more specifically at the current system, the current institutions and practices, we can see that apart from other, the State Council that now carries out this review has no defined time limit for taking a decision on complaints. And the result, or a number of reasons, are too late to really be meaningful. And if a contract has already been concluded, the case may be dropped. So the recommendation is to set clear, challenging, but nevertheless realistic timelines for handling complaints, and correspondingly to make sure that there are resources, that the review body has the skills that are required in order to carry out the review within reasonable time.
Apologies, Daniel. Rana, you should be in the second slide.
Okay, Basma, please.
Yeah. Sorry.
Indeed. Looking at the timelines, in some countries, actually in quite many countries, there are formal limits to set, but the disadvantage, of course, is that the cases are of very varying complexity and requires a great variety of resources to be addressed correctly. And consequently, it would always be advisable to have some flexibility and perhaps to see these short deadlines or timelines as targets rather than binding requirements, and also perhaps as a benchmark when monitoring the process, the outcomes of the decisions and the workings of the review system, so that we can then very clearly create simple statistics saying that, well, 50% only of the decisions were taken within the recommended minimum, or rather maximum, of 30 days, and so on. Well, what are the reasons? What can we do about it? Is the recommendation realistic, or are there other problems to be addressed in order to ensure speedy decisions, but still of an adequate quality? We also, if we look at the next slide, have some problems with the internal functioning of the bodies that now are active in various stages of the procurement process, and where we have, for example, the ex-ante review of the Court of Accounts and the later external audit and so on. And within the State Council, a bit of conflict of roles and the possibility, or rather lack of possibility, to appeal against a decision of the State Council other than to the State Council itself. So consequently, there are some conflicts of roles in the internal workings and in the various activities of these bodies. So it gives an impression that there is a lack of independence and impartiality with respect to the decisions that are taken. So also for a number of other reasons, the recommendation is to take steps to eliminate these different conflicts of roles in order to prevent the appearance of a lack of impartiality and independence. And by the way, I could also mention here that one of the benefits among those that I mentioned earlier of a well-functioning review system is that you do not need any much prior review, authorization, and so on during the process of carrying out public procurement. If something goes wrong, then one would normally trust the tenderers or the prospective tenderers to spot it, and then trust the review system to address it, unless the contracting authorities, the procuring entities, have already themselves, after an initial request, taken steps to rectify the problems. So a functional review system would also very much facilitate the work of both the State Council and the Court of Accounts, and allow them to focus on really the main activities that they have been set up for. And looking again at how things work currently, we have seen some indications of a lack of effectiveness. Decisions are taken, perhaps, but then not much more happens. So the question of enforcement is a crucial one, and there would be a need to create better and more efficient mechanism for doing so, and in that context also to enhance the monitoring of the process so that it becomes evident what is being done, what is not being done, and that measures can be taken to rectify the problems. And the other issue in this context that already David mentioned is that in the absence of any first instance review body, whether courts or a specialized independent review body, the State Council itself is now both the first and the last instance. And this, of course, leads to overload, to delays, lack of capacity, and simply not possible to have all the decisions taken on a well-founded basis and within a reasonable time. And in any case, this leads to a recommendation to strengthen the competence of the State Council in this respect. It evidently is what should be expected to remain the second instance body for judicial review of any first instance review body decisions. But doing so, it will likely have to raise its skills, the skills and experience of the judges, and thereby its ability to well deal with public procurement complaints. And this becomes, of course, even more important when you already have another independent review body where you would already expect people to take well-founded decisions in full knowledge and understanding of the different aspects of the situation. And among the last shortcomings, I already mentioned the problem that if a decision is not taken on time before a contract is signed, then the case apparently will be dropped. And there are also, going back to the initial points about the legal framework and the regulatory mechanisms, there are no measures that are taken in practice in order to suspend the procurement process and the contract signature before the complaint is resolved. And that is, of course, something where you would normally have a standstill period and mechanisms to ensure that the signature of the contract is not possible until any decision has been made on a complaint made during the standstill period. And referring to what was already mentioned about the ongoing work with the new public procurement law, my understanding is that there are already in draft a number of recommendations for the review of complaints, for the setting up of a review body, and for the different procedural steps and the other provisions, including, for example, a standstill period and what goes with it, that are included in the draft. And that is a good sign and something that should hopefully allow us to finalize this particular aspect in understanding of the different issues, and of course with the benefit from this webinar of the experience of foreign countries and what has been shown to work and what not, and what are the lessons to be learned. And consequently, we should then be in a position to finally revise and adopt the whole public procurement law as soon as possible. So these were the particular observations on the Lebanese situation that were found during the MAPS assessment. And it is against this background that I also think that the country representatives will now be able to refer a little bit to any corresponding issues in their countries and how they have been resolved. So thank you for that, and I understand we will now go to the case of Denmark to start with.
Thank you, Daniel. Thank you very much. Yes, we will go to the case of Denmark next on the agenda, but first, let me just summarize or let's just think of some takeaways already that we can have from this webinar. As you said, thank you, Daniel and David. As you said, the main thing that I remember right now is what you said, that procurement complaints are not only of legal issues. They are not only of legal issues. They are measures that are taken to render the supply market, to give more confidence to the supply market. And this, if I may say, this confidence will, for us, at least for Lebanon, we hope that, and it was proven anyway, that this supply market will turn from a collusion market with high collusion to a competitive market open to competition. And this is why you said, Daniel and David, that yes, it was proven that courts are not the main, the solution needed for such a complaint and remedies. These are mainly remedies in the pre-contractual phase. For the approach that you're talking about is to, and this is what have been done, and we will see also the case of Denmark, to set up a first instance body that will handle this complaint. This first instance body will be a administrative, quasi-judicial body. This is our topic today to discuss it, the governance of this body, the resources needed, etc. You said, Daniel, that the importance, and David also, the importance of this body will be the speed of handling complaints, and also the expertise and skills that will be needed to handle complaints in an efficient and quick way. You talked also, Daniel, about publishing the decisions of this body, and this is very important also. So publication of the decisions is very important, and this again, here we go to this big question of access to information and I mean the transparency, etc. Before we continue and see the Denmark case, I would like to open the floor for questions, if you would like. The member of parliaments present with us, you are welcome to ask any question, to address our experts. Please, with any questions. I don't know. I will also check in the chat box if you have questions. Please, the floor is yours. Mr. Nicolas Nahas, member of parliament, please, you raised your hand. You're muted. You're muted. Please unmute.
Sorry. So good evening, everybody, and thanks for the speakers, and thanks for their insight. And I think we are touching a sensitive element which could conclude the discussion on this procurement law, which is a very crucial one, especially in these times. So I have the first question: why should we have a court? Why we should have an independent body? Because the decision is in which form the decision should be taken. Is a legal in the name of the Lebanese population, or is it just an administrative? If the ruling is by, let's say, should be a kind of a court ruling, it's something, or if it is an administrative ruling, it's something else. So we are debating between what is the preference, what is the basic need. Should be a court rule in the name of the Lebanese people, or is just an administrative? Second, if we have two instances, first instance is a agency, and second level instance is a court. So here also the question the same: are we at the same level of the decision making, or let's say the representativity of the decision? So this is a question which is being asked and asked and asked, and we are still debating on this issue.
Mr. Nahas, David, I know that you will be leaving us soon. If you may take these questions, please.
Sure, I'd be happy to. But hopefully Daniel can come in also. First, thank you for the question. And it's one that every country, I think, has to face when you set up these types of systems, particularly when you're dealing with the challenges to administrative agency decisions, or questions about administrative agency decisions. Your phrasing of the question was right on point, in that the first instance decision in many instances is what I would call a quasi-judicial decision. In the procurement context, my understanding is we're talking about pre-contractual disputes, which are going to be disputes about the tendering documents, about the tendering procedures, and the policies. These are really administrative interpretations and administrative disputes. So at the first instance, I think the decision is, if you're asking me to weigh, is more an administrative interpretation than it is a judicial determination. Oftentimes, when you go to the court for the second instance, what you're questioning is, did the administrative agency act within its powers? Did the administrative agency follow its own rules? And that is a judicial interpretation. So in one sense, it's not a typical case where you have a first instance that answers a set of questions and a second instance that answers the same set of questions. In these cases, you oftentimes, the first instance is really asking questions of, how do we interpret our rules and our procedures? And the second instance then is answering the question of, did they do that according to the rules? Did the agency act within the law? The laws that you and the parliament have set for them, did they act within Lebanese practice and Lebanese kind of precedent as to how these things are supposed to work? So it's slightly different in that in a normal court case, I would challenge you because I don't like where your fence is on my land. And we would have, and the first instance would decide, and the second instance would maybe say, look, the first instance made a mistake. In this case, the first instance is interpreting the rules and the procedures, how they should be applied in this transaction. And the second instance is then looking at the agency's action itself. It's a fine point, and you know, I can understand the struggle both in Lebanon and in many countries in trying to address the differences. But that is why I think you can be confident with a first instance that's an independent body versus being an actual judicial body, because it's a slightly different type of decision than a judicial decision, which comes in that second instance. Daniel, I don't know if I
just to clarify things. I fully understand what you have said, but my second question, to enlighten the problem entirely, if the fault which are debating is not a matter of administrative or procedures, is a matter of wrongdoing, is the first instance entitled to take decision on the wrongdoing or mishandling or corruption or whatever it is?
You know, I to be honest, I'm not sure I think in the law, you can describe the type of disputes that would go to the independent body. So that if an allegation is that prior to a contract being awarded, there is actual corruption in the drafting of the bidding documents. There was a payment made to illegally impact that process. It's possible that is a type of dispute that the independent body doesn't resolve, that goes right to court, which I take your point. Certain types of disputes may not belong in the independent body and may have to go to court initially, if that's the allegation. And I think that is a line that gets drawn in the law. When you describe the jurisdiction of that independent body, you focus on the disputes that Daniel and I think have been talking about today, which are the ones that are delaying the procurement process, that involve more interpretation. If you have an allegation of a crime or of a real abuse of power in the process, in the early stages of the procurement process, I think that you can draft the law so that goes straight to court and doesn't go to an independent kind of this quasi-judicial body, because it's a different type of dispute. It's alleging a different act, right? It's alleging a violation of law versus a violation of procedures or interpretation of procedures and policies. So I hope that's clear.
If this is clear for you, Mr. Nahas, we can have also an answer from Daniel. Daniel, please.
Yes, just briefly, I'd like to add a little bit to what David said. I think it is important to keep in mind the specific and in many ways limited purpose of the first instance review body. that is, I would say, to help move the public procurement process forward in a way that corresponds with the requirements in the public procurement law for fairness, transparency, non-discrimination, and so on. And consequently, the review body would normally rule only on complaints that are somehow about failure to observe these principles and the corresponding details that are set out in the law. And then whether you put a label on that as a court ruling or administrative ruling, that's in a way secondary. Because in any case, the nature of the independent first instance review body, it may be judicial one, it may be a court, it may be a quasi-judicial entity, or whatever label you would wish to put on it, depending on the legal system and administrative system of the country. And the only corresponding requirement that we have to keep in mind is the need then for a second instance body to be available to carry out judicial review of the decision of the first instance body. And there I think David has well indicated the principles for this and how to go about it. And this is also why in the Lebanese case, it is quite clear to me that the State Council is and remains the appropriate second instance body. And then whatever label you put on the first instance body and its rulings and so on, it's in a way a bit secondary. And finally, we should also keep in mind that cases of fraud and corruption and so on, and other matters that are already regulated separately in the legislation would typically not be addressed by the review body. And that I hope would be an initial clarification of the matter, but of course there may be more to be said about it.
Thank
Thanks,
you, Daniel, for the clarification. Thank you. Any other question? Mr. Alaoun, any question, anything? Okay. Now we will continue with our agenda and we will move to the case of Denmark. The case of Denmark will be presented by Mr. Peter Gortler, of counsel advocate at Greystone & Company law firm, and he will be presenting to us in 20 minutes the case of Denmark. Please, the floor is yours.
Thank you. Now I would like to use my slides, but I can see you have disabled slides screen sharing.
Yes, now it's active. Please try it.
Okay, just 1 second then. Okay. So, do you now see my slides? Let me press here. Here we go. So, with that, I will get started. So, as said, my name is Peter Gortler. I work with a law firm in Brussels, but I've also been working in Lebanon on the EU project that took place, and I was working with it during the last part from 2016 to 18. I've also had the pleasure of working with several of the experts present today in public procurement matters elsewhere, in the Ukraine, in Egypt, in Azerbaijan, Romania, and other places. So what to talk about today is specifically the situation of Denmark, or rather the experience of Denmark. So let's get started on that. Now, this slide just gives you an overview of how we've gone about implementing procurement rules in Denmark. And of course, Denmark is a member state of the European Union, and therefore the focus has been to implement the EU directives. That does not apply in Lebanon, even though the attempt for the last law that was presented to Parliament was an attempt to approximate the EU directives. Understand that now it's the Untitled model law that is the basis. Now, the way we did it in Denmark was actually in two different manners. Initially, we did what we still do with what is called the utilities sector. Instead of writing Danish rules, we've just taken the EU rules and implemented them. So we've just written a one-page piece of legislation that says, hereby the EU rules on procurement in the utilities sector are part of Danish law. The advantage of that is, of course, that the practitioners have a reference document that is well known internationally. And they can directly compare Danish practice with the case law, for example, of the European Court of Justice, or the Court of Justice of the European Union, as it is now called. But other people protest and say, no, these EU documents are too complicated, too technical for ordinary practitioners to understand. They need to be rewritten in a language that is more understandable in a Danish context. And that's what they ended up doing with the main EU directive, the public sector directive, the one that applies in all sectors except for the utility sectors. And there is a certain logic. The utility sector has very large companies where they presumably have very technical experts also on procurement, whereas the general directive on public procurement applies in all manner of places, from little municipalities up to ministries. At least that's the way that was chosen. And then, of course, there's additional legislation on concessions, defense, and indeed also on national procurement that's not covered by the EU directives. Now, we have then also got a law on the Danish Complaint Board, and that's what I'm going to be talking about, which transposes another EU directive, the one that requires legal remedies to be available. But that directive is actually broad in the way it's formulated. It's up to each member state to decide, what do you want? And as Daniel, Sweden, at least originally, chose to say, we will let the ordinary courts handle the procurement cases, not as in the situation as it would be in Lebanon with a single court having jurisdiction, but the ordinary administrative law judicial system would apply with its own system of appeal. Others, like Denmark, have decided, and like Austria, have decided to create a separate review body or complaint board. But the requirement from the EU is actually exactly as David was talking about, that that board must be what you would call quasi-judicial. It is not to be an administrative entity. Now, these are not very precise concepts that have a definitive meaning. But what I mean by this is that the powers that must be wielded by the complaint board reach above what a normal administrative authority would be able to do, even if they are not at the full level of what a court could do. But I would say in the way we in Denmark or the Austrians in Austria have implemented it, the powers held by the complaint board are very close to those of a court. We have a main law, and under the law there is then an executive order which sets out some of the further details. How is our board then composed? Well, first of all, it's important to underline our board is entirely part-time. Other countries have other approaches. Ukraine, Kosovo, both have complaint boards that are full-time occupations. Ours is composed of two pools of experts. One pool is the presidency. There are 11 judges coming from either our larger municipal courts or the appeal courts in Denmark. And then there is the professional pool, which has 20 specialists. Originally, it used to be that these specialists typically were not lawyers, but were engineers, architects, people who knew about various subjects of trade and enterprise. It has changed over time. They have become mostly now practitioners from law firms or lawyers from the university world. But common is that all of them, the presidency and the professional, are appointed by the Minister of Economy. They get a term of office, during which time they are protected as such, of 4 years, but they are not guaranteed any continuation. This is a secondary task they have in their professional life on top of whatever else they have. The selection of the professional members is actually done for each member by either a public authority or a trade association who will make a proposal to the minister as to who they would like to nominate. So in that way, it's not the minister who directly wields all the power, even though it is the minister who makes the final decision. Now, where do you place such a board? That's, of course, an issue in itself. Originally, we placed it together with the Danish Procurement Authority, and there is no separate procurement authority. Procurement supervision is one of the many functions of what is now the Consumer and Competition Authority, which is an independent agency under the Ministry of Economy. But it was recognized that there was a potential conflict because the authority is responsible for procurement legislation. It may also give advisory opinions on procurement matters, and it can also itself bring challenges before the complaint board, as well as bring challenges before the courts. So therefore, it was not seen as entirely healthy to have them in the same house, so to say. But you can say this is not an absolute barrier because you have the same situation in all the new EU, not in all, but in many of the new EU agencies, which have internal boards of appeal or boards of complaint, which are housed within the institution they serve, just like David was talking about the judges that are stationed in US administrative authorities. However, the choice was made in Denmark first simply to move it to a neutral place. They were moved to the companies registry. That made no sense in relation to the substance, but that was just to bring them to a neutral place. However, what we've done now is we've created something that we call the House of Complaint Boards in Denmark. So this is a new independent authority which has a core secretariat staff and which then, so to say, is the housing authority for a large number of complaint boards. You can see a total of 19. We have 3 different on consumer, 8 on business issues, including procurement, 5 that deal with the environment, and 3 that deal with health. And each board has its own setup, its own mechanism, its own way of functioning. In the complaint board for public procurement, every time there's a case, a panel is set up with 2 members, 1 justice and 1 professional. There can be more, but that's the minimum. It used to be that the minimum was 3, with 1 justice and 2 professionals. That had the downside for the justice that the justice could be outvoted by the 2 professionals. Now it is more safe for the justice because with 2 votes, then it is the justice who has the deciding vote. I'm not sure this is really a good move. It is possibly also simply budget saving. There is a secretarial staff, but different from, for example, the situation in Kosovo, where the staff of the complaint body undertakes research into the matters that are to be heard by the complaint board. In the Danish setup, the secretariat only provides office functions, and we'll see how that is possible in practice. What's the jurisdiction of the complaint board? Originally, it was entirely voluntary. Originally, it was simply a choice for any complainant. Do you wish to use the courts or do you wish to use the complaint board? But then came the new element that Daniel also mentioned, and which I also most heartily recommend for Lebanon, the introduction of a standstill period, during which it's possible, before the contract is signed, to initiate a review of whether the procurement procedure was undertaken in a legal manner or not. And therefore, we have now in Denmark made it mandatory, if you are dealing or if you're submitting a complaint during the standstill period, then you must do it to the complaint board, because there is an automatic mechanism linked to it. At the moment your complaint lands with the complaint board, there is an automatic suspension of the procurement procedure, not forever, but for a limited period until the complaint board makes a final decision on whether it is going to grant suspension or not. So that means that we freeze things momentarily and then later decide whether they are to remain frozen during the time of the complaint procedure. That's not a Danish invention. That's actually something that is imposed by the EU directive. But outside of complaints submitted in this standstill period, then it remains a voluntary option. So you can ask the question, why would I go as a complainant to the complaint board? Well, the advantages are an informal and speedy procedure. Second advantage, I don't need to use a lawyer. I can just go and plead my own case if I want and if I believe I'll be able to. If I win the case, I get the complaint fee back. It's €1,500. It used to be very, very, very low, but then the number of cases rose so dramatically that it was raised in an effort to limit the number of cases coming in. Still different from what happens in the court, where you pay a court fee, you don't get it back necessarily. And then one of the really strong arguments is that the complainant will not run the risk of having to pay costs. If the tendering or if the contracting authority loses the case, they will be asked to pay the legal costs of the complainant. But if it's the complainant who loses the case, they will not be asked, they cannot be asked to pay the costs of the contracting authority. So that gives strength to the use of the complaint board. Who can then bring a case before the complaint board? Well, persons with legal interest. That's anybody who participated in the proceedings or somebody who can provide that they, or can demonstrate that they had an interest in participating but were prevented. And as Daniel already mentioned, if you do not complain in time, you may lose your legal standing because of passivity. So if the problem was the initial terms of reference, you can't just sit back and wait until the contract is awarded. You have to start your complaint at an earlier stage if you want to be sure that you're not found to have lost your legal standing. The Consumer and Competition Authority, as I already mentioned, may actually bring a case before the complaint board, but they have in general refrained from doing so. They have done so once or twice, and they found that it was not really their role. They leave that to the economic operators in the field. But then one of the real strengths, in my opinion, of the Danish system is that in the legislation, we have designated 67 trade associations, as well as giving the similar rights to associations of an equal nature in other member states. They have a right to bring cases before the complaint board without demonstrating any legal interest in the case. Now, the purpose of this is that many economic operators are afraid, if I complain today, what are my chances of getting a contract tomorrow? Now, that may be a warranted or unwarranted fear, but it's definitely a fear in the market. And therefore, there's a strength that the trade associations, on behalf of their members, but without specifying which member they're acting for, can start a complaint in the complaint board. But we don't go the full step towards the Indian system of allowing in a wider sense that any individual can bring a case in the interest of society. We've limited it to these 67 trade associations. How is a case prepared before the Danish Complainant Board? Well, first of all, we have the obligation that the complainant must inform the contracting entity, I am going to complain about you. We don't have the system used, for example, in Ukraine, where you first have to submit a complaint to the contracting authority and wait for them to authorize, to decide on whether they will amend their ways or not. You just have to inform them, I am now submitting a complaint against you. But once you've done that, then it is actually the contracting entity who has an obligation to write a report on the case and submit it to the complaint board. So the complaint board does not do any investigation. It gets a report from the contracting authority, which of course the complainant will be allowed to comment on. After that, there are written pleadings, like in a normal court case. There may be an oral hearing, but just like, for example, the European Court of Justice is moving towards having more and more cases decided only on a written basis, the same is happening at the Danish Complaint Board. Again, a personal view, I think it is a disgrace. I think an oral hearing is an essential part of judicial culture, of a sense of getting justice, of getting your day in court. I find it not a good practice that has developed towards deciding cases on a written basis. But then this is, as I say, a personal view. This is not part of the Danish policy. When parties are before the board can recommend that they use lawyers, but cannot require them to do so. And it can also allow intervention by third parties, such as, for example, the winning tenderer, who may want to support the contracting authority in stating that the procedure was perfectly legitimate. What are then the powers of the board, as we talked about? The quasi-judicial powers. These are powers not discretionary given by the Danish authorities. These are the powers required by the EU directive. First of all, they must be able to suspend the procurement procedure. They must be able to annul the award decision. That's the administrative law decision. I am going to grant the contract to this economic operator. Now, if that happens, for example, in Dutch law, then it has, to the best of my understanding, an automatic effect that if a contract has been signed, the contract is invalidated because the administrative award decision was invalidated. That is certainly not the case in Denmark. In Denmark, a signed contract will live on happily, no matter that the award decision was invalidated. That's, of course, a problem issue, as Daniel was also talking about, and that's why the EU came up with the system of ineffectiveness that I'll say just a few words about before closing. The complaint in Denmark may award damages. Originally, they could not. Originally, that was seen to be a court function, just as you were discussing in relation to the question from the Member of Parliament. But it was found in Denmark that it would be silly not to let the board award damages, because otherwise, following each and every one case at the board, there would be a secondary court case concerning the damages. So therefore, the power to award damages was granted to the board. And you can see even more towards judicial powers, the board can also impose economic sanctions. But still, in relation to the issue you just discussed, let's take a case where the procurement goes wrong because of corruption. That does not mean that the board cannot deal with it. The board will still deal with the fact that the procurement was done incorrectly. The fact that there was corruption may then lead to criminal charges against the corrupt official, but that is a separate issue. That will not be dealt with by the board. And it could even be that the normal courts afterwards find that the evidence is insufficient for finding the official guilty of corruption. But the board will still deal with the impact the behavior has had on the validity of the procurement procedure. Other classic borderline issues is bid rigging. The board will not deal with bid rigging. That is a pure competition law issue, collusion between the economic operators. The board is only checking on the behavior of the contracting entities. And indeed, as I already mentioned, we also have in Denmark the fact that once the contract is signed, there is no competence for the board, except that the EU created a new mechanism that is also applied by the board. In certain grave situations, that is where a contract is signed within the standstill period or where no notice has been made at all in the official journal concerning the procurement, then the contract will not be invalidated, but it will become ineffective, which is a kind of compromise solution so that you do not interfere with the validity under contract law, but you interfere with how it works in the market. The contract cannot be effectuated. It becomes ineffective. And I've given you a little slide that gives an overview of that. How to avoid that? That is, if you think you're in a situation where you are entitled to go ahead without publication of a notice or by following a procedure that is questionable, well, then you can put a publication in the official journal saying, we now intend to enter into this contract, and wait the 10 days, the standstill period. And if nobody protests, then that does not mean that your procedure is now legalized. It just means that now you cannot be hit by ineffectiveness. So that is a method that's used quite often in Danish procurement. Finally, just a few words about appeal. Decisions of the board can be appealed to the courts. And just like the discussion we had before it was my turn to speak, here is an issue. What are you appealing? And in Denmark, that's not clear in the law. And we therefore have both cases where the appeal is brought as a second round and appeals where it is the contracting authority that sues the board concerning the validity of the board's decision. And indeed, we find many variations on this theme. The European Court of Justice, for example, it is the decision of the General Court that is at stake in the appeal before the Court of Justice. It is not a second round of hearing the case. Whereas, as Daniel was mentioning, normally in a national court system, whether administrative or civil law, an appeal is a second round. And in Denmark, both approaches are actually currently being applied without that being an issue. But I think most people in Denmark perceive the complaint or the appeal to be a second round. And it was therefore found to be not very correct when one contracting authority decided to sue the board, but the case was declared admissible. Finally, a little bit of statistics, taking the year 2019 as the base point. 93 complaints in a year. Some years have been larger, some years have been fewer, and certainly lifting up the complaint fee to the 1,500 euros has had its impact. Out of the 93, 46 cases were decided on substance. The rest were thrown out on admissibility. And 45 out of 46 were decided based on written procedure. As I said, my personal standpoint is this is not a good way forward, but I feel I'm talking against the wind in saying this, the way the winds are blowing currently. If we look at the 46 cases, the success rate is at 39%. That means a little bit less than half the cases are won by the complainant. The majority are won by the contracting authority. But you'll see out of 46 cases, only 4 were appealed. So that means that the persuasive quality of the complaint board is rather high. People accept what comes out of them. Interim measures is another, in my personal opinion, disgrace, Because interim measures are important. As one Canadian lawyer put it, in public procurement, you have only one window of opportunity, and that's to get interim measures imposed to stop the procedure. Because if the procedure keeps running, then you might as well give up, because then we're just talking about damages at the far end of a long legal procedure, and that's not very interesting for your client's position in the market. So therefore, in my personal view, again, the award of interim measures should be the normality. That should be the point of departure. Otherwise, why are we having a standstill period of 10 days? You can't conclude a matter in 10 days. You can start a matter, but if it's not supported by interim measures, then it has little real meaning to run these cases, except in the long run that you're building up case law, etc. But as you can see, in Denmark, it's 8% of cases only, 8 cases out of 93 that were granted interim measures. Average procedure, 5 months. That is significant. That is way below what the ordinary courts are able to turn out. And that's why there is a strong selling point in a separate complaint board. It can do business fast, and it can do business that convinces its clients so they are happy with the decisions that come out of it, or at least they accept the decisions that come out of it. So that brings me to the end of what I wanted to present to you at this stage, but naturally, like the others, I'm also open to questions. Thank you, Rana.
Thank you, Peter. Thank you very much for a very informative presentation. I mean, we have seen a lot of issues that were subjects of discussions regarding this procurement review body. You have exposed the governance of the body in Denmark. You have highlighted you have asked the question where to put it, where to host this, and this is one of the major questions that we are discussing now in our case. So where to host it in Denmark? You started hosting it at the Ministry of Economy, and then you realized that this was not the ultimate solution because of potentially of conflict of interest, and then you moved it to a neutral. You said a neutral agency, which was the company's registry. This is a very good option. I mean, it's something not related to public procurement. However, it's neutral, so this could be a solution. You talked about voluntary or not voluntary, mandatory basis, the fees, the cost of filing a complaint. About oral hearing and how you think that this is essential for the decisions of how the decisions are appealed in Denmark. Thank you, Peter. I open the floor now for questions. Please ask your questions. And OECD. Any questions, please raise your hand or put the question in the chat box. Okay, I have one question here, Daniel or Peter, or regarding you talked about the first instance complaint at the level of the review body. Asking about the first of complaint at the level of the procuring entity. What can you tell us about this? Is it mandatory? Is it do you consider it as a first instance complaint? About this, is it in your country, for example, in Denmark, Peter? Is it a mandatory thing to do? Please.
Well, no, it's definitively not mandatory. The EU rules on complaints say specifically a member state can make a first complaint to the contracting authority mandatory. but they can only do so if they then suspend any time limits for bringing an actual complaint before the complaint body or the courts. So those are the conditions. In, for example, Ukraine, when I was working there, the Ukrainians made a system where it was mandatory first to submit a complaint to the contracting entity. It was seen as reasonable that the contracting entity got a chance to look at its procedure and decide whether it itself could see that there was a problem. In Denmark, we decided not to make that mandatory, but it doesn't preclude that you can approach. But the problem is that if we're in an ongoing procedure, then at the same time, the contracting entity has an obligation to be neutral, to be non-discriminatory in the way it deals with all the economic operators. So that means that I can't have a long telephone conversation with one economic operator who wants to tell me about a problem he or she sees in the procedure. I would have to receive that message, and then I would have to give a response that I copied to all the contractors in order to ensure that there was treatment of them. So this is one reason why it was seen not to be practical to go forward with requiring first a complaint to be submitted to the contracting authority, but simply to have this rule that I mentioned. When you do send off your complaint, you have to give notice to the contracting authority, I am now complaining about you.
Peter, anything to add, Daniel?
Well, I would consider it something useful, but at the same time, not necessarily very different from what you also usually have in the public procurement law. That is, some provisions for how to request clarifications if there are any unclear aspects of the tender documents or the like. And usually with quite specific requirements for the query to be published, made available to anyone else to look at, and also the response to it. And there I wouldn't see any greater difference between that on the one hand and any, say, complaint within quotation mark that would be about the the deadline for submission being too short, or the tender document being a little bit biased, or the award criteria unclear, and so on. So I would rather try to avoid formalizing it too much, and also to make it mandatory. On the other hand, it could perhaps, and I would be open to hearing other opinions about that, it could perhaps be dealt with by referring to or expanding on the provisions that would already be in place for how to demand clarifications to the tender documents and the like. That I would see as the simple, practical solution. And I would then also not label it as a formal complaint. I would limit the use of that term to something which is clearly against a formal decision or action, and rather talk about a request for clarification or request for modification or whatever. And I think the EU directives actually clearly state that such a first contact with the procuring entity is not considered as a complaint in the same way as one made to the first instance review body.
If I can just add one comment to it, the needs here of saying a less formal version of complaining than the full submission of a case is exactly what is served to some extent by the fact that the Danish Public Procurement Regulatory Authority, that is our Consumer and Competition Council, gives opinions. So that means that if you are an economic operator, or for that matter, if you are a contracting authority who are in doubt about whether something can be done or should have been done this way or another, then one step that you can take, contact that Consumer Competition Authority, who will give you their opinion, binding opinion, an advisory opinion. They will make public their website, and which will then give you some information about at least what a qualified body thinks of the issue that you have raised. That has served as a means of deflecting a lot of cases that could otherwise have been groundless at the complaint body itself, simply filtering them through these opinions.
So there indeed you would have a complementary role of the Public Procurement Authority that would not actually overlap with that of the review body, but would nevertheless be a very helpful extension to the various processes for resolving problems in public procurement in a quick and clear and competent manner.
Thank you very much. I have a question for you, Peter, in the chat box from Ajram. So she's asking, from your experience, is there any similarity between the case of Lebanon and the case of Denmark that we can build on?
That's a good question. But yes, of course there are. What many people might answer in the first round is that Denmark frequently comes out in international evaluations being one of the least corrupt countries in the world. Lebanon does not quite have that standing currently, and some would underline that this is a difference that therefore would require a different approach. But one should not be misled by the standing of Denmark. We also have corruption in procurement, part of it economic and part of it what I call stupidity corruption. We've had a very long tradition of various contracting authorities being convinced that they knew what was the best product in the market and who was the best supplier. Not that they were getting paid for it, they just knew that this was the best. Like any Dane would say, of course, Bang & Olufsen is the best hi-fi equipment you could buy, which is not quite the case, but never mind. And therefore, there was a lot of abuse in that form. And therefore, we did face the same problem, that there was really a need for an effective complaint system that could satisfy the economic operators in the market and give them the feeling that if they did not encounter reasonable conditions, they had somewhere to go. So that was the task on this complaint board when it was set up. And that's something they managed to rise to. And I think exactly because of its combination of having a strong judicial element in the chairman being a practicing judge, and then having the judicial evaluation supplemented with at the beginning, 2 professional experts, which meant that the decisions that came out of the demonstrated a clear comprehension of not only the procurement rules, but also the subject matter in which the procurement was being done. And that led to this remarkably low appeal percentage that we see against the decisions of the Danish Complaint Board. So in that sense, I think the need is there. and the solutions could be very similar. Now, just to come back to the question of where to locate it, one thing that was never considered in Denmark, but which in my personal opinion could also work very well, would be to place it in the same location as the courts. So you could attach a complaint body to be a subunit at the State Council if that was something that could be satisfactory. That is how it works at the Court of Justice of the European Union. The Court of First Instance is part of the same institution as is the European Court of Justice, with separate administrations, but part of the same institutional setup. And that does not cause any conflict in relation to the handling of appeals from the one body to the other. But this is, of course, a purely Lebanese issue also about where you would want to place an institution such as an independent review body. I should just add one thing to your summation, which is that actually all the three options used in Denmark, first, the association with the public procurement regulatory body, secondly, the companies registry, and thirdly, the House of Complaints, they're actually all three different agencies placed under the Ministry of Economy. So it wasn't that the separation was entirely and dramatic. It was simply institutionally that they were placed in three different agency lines.
Thank you very much, Peter. Lina, you had a question in the chat box and you have raised your hand.
Yeah.
What do you prefer?
Yeah, thank you. Thank you, Peter, for giving us this very insightful experience and country lesson. But I want to just ask you about the eligibility of the complainant. And you clearly stated that these should have either being interested in the bidding process or indirectly or directly involved in an association for them to be raising the complaint on their behalf. But in Lebanon now currently, we have a lot of citizens' voice and the media that are alleging for on procurement malpractice, etc. Having said that, it might be some leakage of procurement processes that are, by definition, is not regular to have these leakages. But since the information is on the floor, shouldn't they have a way to access this the complaint body, or could the complaint body itself react to this kind of media allegation, etc., by themselves initiating an investigation or not? What is your opinion on that? You're muted.
You raised two very interesting questions. The first question is one of whether the agency should be involved in investigation. Now, to some extent, that is the case in Egypt. To some extent, that is the case in Kosovo. And in both examples, I do not think that this is a good way forward. I think the complaint body should remain a reactive body, like a normal court, hearing a case brought before them. And I think the mechanism used in the Danish system works very well, that the contracting authority has a reporting duty on the facts of the case. Then there is the issue of how should society react to the fact that newspapers, private citizens may see procurement malpractice going on. Well, in my personal opinion, this falls outside the scope of what a complaint board authority should be. The complaint board is a mechanism for resolving the disputes between the economic operators that are bidding for contracts and the contracting entities that are offering contracts, and it should reach no further. Other issues related to public procurement, a general feeling that abuse is ongoing, that is something for parliamentary committees, that is something for possible civil disputes before the court, if you can find a basis for claiming your legal interest. And of course, if you want to be very expansive, as I mentioned in my presentation, you can go to the Indian model of identifying certain issues in society where you will allow any citizen to start a court case based on defending the interests of the nation. But that is a very unusual judicial procedure that is not found in many other countries, and to the best of my knowledge is not found in any of the European countries as an example. So I don't think that is the way forward. I think the way forward is now to get established the professional complaint body for the operators in the procurement market. And then the other issues will have to be dealt with by other means.
Okay, thank you. Thank you, Lina. I still have one question in the chat box from Abdelmajid, our colleague. As we know, there are different approaches for the fee being paid upon submitting a complaint. Fees can be either flat fees. So this is for you, most probably, Peter, you have raised this issue. So fees can be either flat fees, irrespective or respective to the type or value of the contract, or a deposit in contract value, where usually a minimum and maximum payments are identified. Which approach is best, in your opinion, does best fit to the Lebanese situation?
I think that again, I'm not here as an ambassador for Denmark, so I'm not trying to sell the Danish solutions as being the best in the world. But on reflection and also on comparison with what we've discussed with other countries, I think the approach taken at the beginning of the Danish Complaint Board was a very wise one. As I recall it now, at the beginning, the fee was set very low. It was somewhere 200 to 400 euro, returnable on success. And it gave the predictable problem that the number of cases became very large. And of course, you can then start adjusting if you feel that now there are, as they are called in English, spurious cases, that is to say, unserious cases that are simply brought by people who want to create problems in the procurement market, and it's easy to do so because there is a very low fee. So therefore, the response is often then to say, well, we'll increase the fee level in order to have an economic break on how many cases are being brought. And that is entirely possible, but I would start, when I was initiating this complaint board, with a very low barrier, with a very low fee for bringing a case, so that they could start building up a case body. And then if that becomes unmanageable, well, then maybe you have to start adjusting by increasing the fee. Now, in the court system in many countries, you pay a fee that is proportional to the value of the claim. Here, it would be proportional to the value of the contract. Again, that is a tax policy issue on which you can have a tax policy opinion. My personal opinion is that a reasonable flat fee is better, because that is a predictable and announceable amount that you can simply put up. It will cost you X to submit a complaint, no matter what the value of the contract at stake is, rather than imposing on people to consider the balance between the percentage cost and the value of the contract. But that is definitely a tax policy issue where I have my opinion, but it's not a scientific opinion in any sense of the word.
Thank you, Peter. I see that we do not have any more questions in the chat box, and no hands are, I don't have any raised hand. Still one thing in the chat box. Okay, it's not a question. Yeah. So, yes, Peter, anything you would like to add?
I can see the question, what about the qualifications? Well, in the Danish system, chair must be a sitting judge. It must be somebody who is currently a judge in a municipal or appeal court in the Danish legal system, and who will then be doing this in their extra time. I don't know how it is in Lebanon, but in Denmark, judges often have tasks in their extra time. They are chairman of committees, or they do private arbitration cases, or whatever. And this is one of the many options where they're actually serving another public purpose. The board members do not have any predefined set of qualifications. But of course, each of these trade associations or public authorities that nominate persons for the board will have an interest in nominating qualified persons. And as I said, typically the emphasis has shifted from practical experience to legal experience. You find a lot more lawyers today amongst the professional members, but there is no set qualification criteria for the professional members.
Okay, thank you again, Peter. Now we are at the end of our webinar, this first day webinar, and we will be closing for today. Tomorrow, don't forget, we will be also having because I had questions on that, the country cases of Romania, Croatia, and Georgia. Now to close,
Rana, sorry to interrupt.
Yes.
Maybe MP Alaoun has raised his hand to say something. So
sorry, sorry. So before we continue, please, Mr. Aoun.
Yes, thank you. It's the last question. Hi, thank you for your presentation. Just a question regarding, I heard that for the complaints in the Denmark model, let's say there's a judge presiding the question that we are debating actually here in Lebanon during our discussions is one of the questions we're debating actually about if it should be headed by a judge or not. But all this also depends on how many levels of appeals will happen after the complaint is made for the first time. So in the case of Denmark, when you have a judge, at least at the first instance, where you have a complaint, what happens next? How many levels of appeal you have after that? Just to know if on this issue, please.
Well, that's very easy to answer. Denmark has a system of courts in 3 layers, and different from Sweden and many countries, we do not have any distinction between lines of court. We have a unitary court system. So every court deals with administrative law, criminal law, civil law. And there are the 3 levels, but your right of appeal only covers 2 levels. So if you start in the municipal court, then you have a right of appeal to the courts of appeal. There is also a Supreme Court, but that requires special permission, as the English call it. It requires leave to get a second round of court appeal. So what will happen with a case that comes from the complaint board? It will go to the ordinary courts, typically the municipal courts, unless for some reason, because of its size, its importance, it is lifted up to start in the Court of Appeal. But otherwise, it will be heard in the municipal court. And you will have 1 chance of judicial appeal after that. Now, what about the judge who sat in the complaint board? Well, that person will, of course, as an individual, have a conflict of interest. So he may be, or she may be, a member of the same court that is going to hear the case, but they will not personally be sitting on the bench hearing that case, because they, of course, are conflicted by having made the decision that is now being appealed. So that means that for procurement cases, there will be essentially 3 layers in Denmark. But you can almost guess that if we are down at 10% appeals from the complaint board to the courts, then the number of appeals from the first instance court to the second instance court is presumably also rather low. So it's not seen as a major impact on the workload of the Danish court system.
Okay, thank you.
Thank you all. Sorry, we are already late. We are it's 5:15 already. We will be closing. Thank you for a very rich day. We will close with our partners, World Bank and OECD, Mrs. Lina Fares and Mr. Jorge Kazan. Please, Lina.
Thank you very much. Very interesting experience. I'm just to have in 2 sentences saying that the World Bank is committed to support Lebanon to advance the public procurement reform, but this is not sufficient. If we didn't have a solid partner in front of us, we wouldn't have went that far. We have, and this webinar is an example how the government is taking very seriously this agenda. We have also the efforts of the Institute of Finance that is leading the effort, but also with a great support of all the stakeholders. In particular, we are very happy with the Parliament revisions, and we know that the in-depth that they are going through it is leading for sure for a successful, passing of this law. We believe that the drafted law has a significant modernized approach, including a lot of features that makes the system more transparent, fair, and competitive. And I hope that with the law passing, the Lebanon will be put back into the screen for international and national investors. Definitely, the country will need to exert a lot of efforts to not only pass the law, but later on to be implementing that law. And this is why, despite the fact that it is taking a lot of time in reviewing the law, we hope that we close the loop on this particular article, given that we now from this, only from this webinar, we see that there are a lot of solutions, and up to us to decide what is the best approach. Definitely having a dispute board that is independent, technically very solid, and efficient in working efficiently will be bringing back the trust of the citizens in the systems. I am sure that this will be, I think that based on my experience in Jordan, it was funny to realize that even those complainants that didn't succeed in having the decision in their favors were happy, because they said clearly that if it is not in our favor this time, next time it might be in our favor, and this is giving them trust in the government. And I believe that this is a very good opening window for us to be cleaning the image of corruption and that we have. Of course, procurement is part of the corruption, but is not all the corruption. Thank you.
Thank you, Lina. Thanks. And now we close this webinar with the representative of OECD-SIGMA, Mr. Jorge Kazan. Jelu.
Thank you, Rana. Indeed, excellent event, very good presentations and interesting discussions. The last year, Institut de Finance has been working intensively on drafting the new law on public procurement as part of a comprehensive reform of the public procurement system. SIGMA contributed to the policy discussion on various issues related to the drafting process and assessed the draft of the new public procurement law in different stages. Constant assistance and guidance were ensured during the discussions organized in Parliament between the Institut de Finance and the Parliamentary Committee. In this context, SIGMA prepared a number of written explanation recommendations regarding to a number of topics and how to address them in a proper manner. and also prepare the comprehensive outline containing the description of the steps that should be taken to achieve the goal of having a well-structured organization of the procurement profession. Indeed, one of the most sensitive issues during our collaboration in the last period was the establishment of the procurement review body. We discussed a lot on this topic, explained the importance of such independent institution, and presented some examples of good practice from other countries. I would like to highlight two main reasons why a procurement review body is really a good instrument within the institutional framework, not only in Lebanon, but in many other countries. Actually, I will only repeat a few ideas already mentioned by other speakers during this day. So one important reason is rapidity in solving complaints, a relative short period for making decision on various cases in public procurement. It's actually crucial for a proper functioning of the whole procurement system. And another reason, specialization in public procurement matters. Only a body whose activities are particularly, I would say exclusively, dedicated for solving procurement cases can gain relevant experience and efficiency in this regard. This is not a duplication of, or it will be not a duplication of different activities of the institution. It is basically a two-stage process in solving complaints, with the advantage that most of the cases we expect to be solved in the first stage at the level of the review body, and only few of them will go further to the second instance. I will finish my short intervention by saying that if approved, the new public procurement law will mark significant development in this area. In our opinion, the public procurement law will lay the foundation for development of a completely new public procurement system in Lebanon. And of course, the institution involved in development involved in the public procurement reform will need further methodological policy advice to complete the regulatory and methodological framework deriving from the new public procurement law. And of course, in this context, SIGMA is ready to continue and will continue to support the reform process. Thank you very much.
And now we arrive to the end of this first day of webinar. I remind you that day 2 is tomorrow with 3 different experiences. I thank you all, the speakers, the audience, member of parliament who attended the webinar, and we're waiting for you tomorrow at 3 p.m. Bye. Thank you.
Thank you, Rana. Thank you, Daniel. Thank you, everybody. I think it has been a wonderful seminar, really. And thank you, Lina, for helping us advance this agenda.
Thank you. But we need to brainstorm, right, later after the seminar. Okay.
Great.
Thank you.
Bye.
Okay. Bye. Bye.
Thank you all. Bye. Bye.